6th meeting of the Rehoboth Beach Board of Adjustment. This afternoon, the board will consider the request for an area variance at 509 Lee Street. This is a large, odd-shaped lot created by a legal subdivision in 2008.
Excuse me, Chair, I need for you to pull the microphone.
Sure. The property owners seek an area variance allowing them relief from the side yard setback requirements of the zoning code. We thank everyone who's here today for participating and for being interested in the work we do here. If any of you want to speak, you'll be permitted. We only ask that you address the issues before the board and speak loudly because we have a court reporter here, and please no cross conversation. Everyone who chooses to speak during the hearing will be required to give their testimony under oath. I'm going to ask our attorney, Mr. Townsend, to administer the oaths. So let's start working our way through the agenda today. First order of business is the call to order. So I can see that we have Randy Mason, Walt Cassell, Jan Conacy, and me, Jerry Capone. So we have 4 members present. Barry Brandt will not be here today. So we do have a quorum to proceed with this meeting. The next order of business is the verification of meeting and public notice section. So I'm going to ask the clerk, Madam Clerk, would you please fill us in on how you went about noticing the meeting and sending out notice to the neighbors?
The agenda was posted in City Hall and on the city portal on July 19th. It was also sent out from the portal on July 19th. The agenda was amended and reposted in City Hall and on the city portal on July 20th and was sent out from the portal on July 20th. The public notice for case number 0521-02 for the property located at 509 Lee Street was posted in City Hall and on the city portal on July 1st. The public notice was published in the Cape Gazette on July 6th and July 9th, Coast Press on July 14th, and Delaware State News on July 8th and July 9th. Notification specific to this case was mailed out to property owner addresses within 200 feet of the subject property, and signage was posted on the property. That's all I have, Chair.
Okay. And now we come to the correspondence section. Did we receive any correspondence?
Yes. There's one letter, I believe that probably should be general correspondence, and then there's another letter specific to the case.
Okay. So the letter specific to the case comes from Michael Grace, 314 State Road, and we'll hold off on that and discuss that during the hearing on this particular case. But the other letter we received, the general correspondence, is from Kitty Cole, 37 Olive Street, and it really doesn't apply to this case, but I'm going to take my prerogative as chairman, and I'm going to read the letter, and I may circle back to it later on when we get to the hearing. But this is what she had to say. And the letter is dated July 6th. Dear Mr. Capone, this is a copy of a letter I wrote 3 months ago. Quote, in reply to the letter you sent me February 23rd, 2021 from the City of Rehoboth Beach Board of Adjustment requesting a variance for 42-inch fence for Mr. Mitchell. What happened? A nice open white vinyl has been removed and a solid white vinyl fence has replaced it. Mr. Mitchell already has a 6-foot solid white vinyl fence 100 feet long. Why didn't I get a letter about that fence? The city should not allow 6-foot solid white vinyl fences to enclose yards. It is inconsiderate of your neighbors as they block ocean breezes, open views, harmful to eyesight as the glare is blinding when the sun shines on the white vinyl. If a neighbor on each side of a property installs a solid white fence, it would be very confining and hot in summer. There are several in Rehoboth now, and when people build pools, will the city allow these tall fences? If so, Rehoboth will not look the same. There are 4 in my neighborhood now. Why not have open fences 3 or 4 feet high? Please respond, as I'd like to know your feelings about this. Thank you, Kitty Cole," and she gave me her phone number. So I'm going to tell you that I did call her back, and I just told her that I think that the fence that she's talking about, although maybe not a fence that most people would consider attractive or appropriate for that location, is compliant with the zoning code, or at least appeared to me to be. So anyway, I wanted to read that letter into the record, and now let's move on with the rest of the agenda. The next agenda item is the approval of the minutes. Has everyone had the chance to review the minutes from our last meeting?
Yes. Yes.
Okay. Are there any comments or suggested modifications to those minutes? No.
No.
I take it by your silence, Jan, that's no?
Yes, oh no, I said no, I'm
Okay.
shaking my head,
And
sorry.
I'm the guy with the hearing problem, so just
Okay.
don't forget that. All right, so is there a motion to accept and approve the minutes?
I'll make a motion to accept and approve the minutes.
Barry, are you going to second that?
Randy, yes, I will.
I'm sorry, Randy. Okay, all in favor signify by saying aye.
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 Opposed? You passed unanimously. All right, any old business, Madam Clerk?
There's none.
All right. All right, it's time for the case. So I'm going to ask the parties, would you mind if your client sat at the table here?
That's fine, if you folks want to go up to the table. And just for the record, this is Linda Rockinelli and Frank Falcone.
Right.
They're the owners of the property in question. I
All
will
right.
be there with them, but I'm going to use the screen.
Kind of figure. Well, welcome, folks. All right, so now we begin the hearing, and let me just give you a little background on this now. The hearing today will be, we will be considering whether or not to grant an area variance, and under Delaware law, there are 4 factors that we need to consider when we decide these issues. One is the nature of the zone where the property lies. 2, the character and use of the immediate vicinity, and whether removal of the restriction on the applicant's property would seriously affect the neighboring properties and their uses. And finally, whether failure to remove the restriction would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. So that's the charge that we have in deciding this case. So let's begin with the building inspector's report.
Thank you, Mr. Chair. So in 2014, the city commissioners adopted this ordinance, which was the calculation for the lots greater than 52.5. This is in response to that with case number 0621-03. The applicant is seeking a side yard variance here from the required, I think it ultimately ends up being 25.8 feet. So they're seeking today a 9.8-foot side setback variance to allow a 10-foot setback on that state road side. The property is located at 509 Lee Street under tax map identification number 334-19.08-89.01. The lot measures a total of 8,470 square feet and is situated in the R1 residential zoning district. There has been no submission for a building permit at this time of concluding this report. Again, the subject parcel was created by a lot partitioning application number 0308-01, approved on April 14th, 2008. And I felt it appropriate to include some of that documentation in the minutes as I was getting some public questions. So in an effort to answer those public questions, I included the actual documents from those hearings. The setback requirements during the cycle code, and during the code cycle require the following: front setback 15, rear setback 10 foot, side setback 6 foot, and 16-foot aggregate. 270-26 side yards was amended by ordinance number 0114-01, adopted January 17th, 2014, that set forth the side setback calculation requirement on lot frontages greater than 52.5. 509 Lee Street has a road frontage of 80.65 feet. The calculation set forth by the ordinance is applicable as follows. It's broken down two ways, and you take the lesser of the two evils here. Lot frontage is 80.65 feet. You divide that by 50, you get 1.613. Take that times 16 feet, and the max required under that calculation is 25.80 feet. If you do the square footage calculation, 8,470 square feet divided by 5,000 square feet, you get 1.694. Take that times 16, 27.10 feet would be required under that. Again, the lesser of the two calculations is applied here, making the side setback requirements for the lot as follows. You have the 6-foot minimum on one side, and then an aggregate, which would be 19.8 remaining, would be required on the other side. The 6-foot is a minimum setback requirement, giving the owner applicant the ability to situate the house left or right for purposes such as parking requirements, centering on the lot, etc. Therefore, under the code, the property is required to have a total of 25.8 feet side yard setbacks with a minimum of 6 feet on one side. The applicant is seeking a variance to reduce the required setback along State Road from 19.8 feet to 10 feet. The recommendation is on a variance request, both the city and the applicant agree that the proposal is not compliant with the city code. It is the Board of Adjustment's role to determine if the legal standard for a variance for the city code is appropriate.
All right. Anything else from the building inspector?
No, sir. Thank you.
Mr. Robertson, your turn.
Thank you, Mr. Jennison. Ms. Womack, if you could put the, turn the screen on. Ann? Oh, sorry. I didn't know if you heard me. Thank you. Maybe you could zoom in a little bit. This is just sort of an overview of the neighborhood. The property that we're talking about, which I'll get into in obviously more detail, is the one that's outlined in yellow. This is from the Sussex County's assessment records, and it shows their property, the property next to it that was the subject of the partition, and just sort of a general vicinity of what's around here. And I thought that would just be helpful to sort of start, although I know everybody in the room is familiar with this corner of Rehoboth, but at least that's up there. For the record, my name is Vince Robertson, and I'm an attorney with Parkowski, Yerk, and Swayze here in Sussex County. And as I mentioned, I think before we started, I am here with Frank Falcone and Linda Roccanelli, who are my clients and are the owners of this property. And we are talking about 509 Lee Street. We are seeking, as Mr. Janis stated, a variance from the application of Section 270-26A, but specifically Note 2 of the Rehoboth Beach Zoning Code, which is kind of an obscure provision in the code because it doesn't apply to most properties, and the properties it does apply to generally don't look like this one as far as the way in which it works. And as Mr. Janis stated, that code section, and particularly that note, provide greater setbacks for lots that are wider than 52.5 feet or larger than 5,250 square feet. I would point out at the outset, just to kind of give you a frame of reference, and it's not a survey line, that yellow line, that's just the county's sort of overlay for where the property is. But the interesting thing is that note applies to lots that are wider than 52.5 feet, but about half of this lot is neither wider than 52.5 feet nor wider than the standard 50-foot wide lot we have in Rehoboth Beach, because it is a triangle. What I want to do before I get into the substance of this is talk about Mr. Grace's letter. That's the one in the record. And the reason for that is he made some representations, and I don't know, I just want to clear up the record. I don't want anybody to think that I made misrepresentations about neighboring properties. So in reading Mr. Grace's letter, and I don't know if he's here, okay, this afternoon, at the outset, I want to say he does not appear opposed to the application. He just had some questions about it. One of the things that he did talk about was whether or not there was the Delmarva Power and Light property actually bordered the property, or whether his property was adjacent to this property. And I just want to show for the record. So that's another copy of the Sussex County assessment map, and you can see there's a triangle of about 30 by 39 by 40 that's in between these properties, and you can see the assessment records on the right that show it's Delmarva Power and Light DP&L. So that just shows that there's a piece that's next to it that is owned by DP&L. It shows up on our survey. You can see, and it's tiny, but that references the DP&L property next to ours. Actually, in our client's deed, calls out DP&L as one of the adjacent properties, as well as Mr. Grace's property. So his reference, DP&L being an adjacent property. Now, in fairness to Mr. Grace, I can understand where he would have come from on that, because you think of a DP&L property as probably having a power transmission box or, I don't know, some sort of electrical equipment there. There's nothing there that would indicate it's owned by DP&L, and actually there's a driveway there that, I don't know if DP&L installed it, but it is owned by DP&L on the land record. So I just wanted to clear that up because I think it sort of plays into some of this, the relevance of this application. So in terms of the impact of this on his property, he's not actually adjacent to it. And I don't know if you realize this, we're not talking about the rear yard setback, we're talking about the side yard, which is along State Street. And the rear yard of our property, actually, the way this site works out, and I'm going to go to a bigger survey. And if you could zoom out a little bit. So because of the way this property is shaped in relation to DP&L and Mr. Grace, if you can see, the convergence of the two side lot lines are actually here, which is further back than the rear setback line that would come into play. So because we've got these two, this is weird, there's a little bit of a delay, so my fingers are showing up on the screen slower than me moving it. That's really strange. But anyways, you can see this point of convergence right here actually is further into my client's property than the setback on the rear otherwise would be. And then on top of that, remember that this is a 30-foot triangle here, so there's about 30 feet from here to here, plus 10, plus some additional land to get to where the two lines converge, and then because there's just not enough space here at the rear of the lot, you're even further back off the setback line for the rear than you could be on probably any other property in town, just the way this one's shaped. So the point of all that is I understand his concerns, but because of everything coming together on this property, he's got greater separation than he ordinarily would have. Now, he asks about measuring where the other house next door on the property identified as A on this survey is, how far off the back setback line it is. I will tell you, we didn't survey that. I was not going to go trespass with the tape measure or anything like that, but it's fairly close to where this one is. So at any rate, I just wanted to point that out. The other thing is he talks about desiring my clients to fund a sidewalk. And I looked at it. I don't think the Board of Adjustment has the jurisdiction over sidewalks and who should install them. But just since it came up, this is the sidewalk code from the city of Rehoboth. And basically it says you have to install a sidewalk if you pull a building permit and more than 50% of the lots on that street already have a sidewalk. In this case, on Lee Street, that's pretty good. This is another blow up of the county's tax map. Nobody in Schoolview has a sidewalk. That whole neighborhood, it's street and front yards. There is a sidewalk that stops on State Road, but it does not continue all the way around State Road to either the school or up to where the intersection with Route 1 is. So, he has a concern. I don't know that this is the right forum for it. It may be something to take up with the mayor and commissioners, but under the rules, there's nobody in this section of Rehoboth that has sidewalks, so I don't see how that could be imposed legally anyway. Moving forward, I also, because we got that letter from Mr. Grace, we did reach out to the neighbors of the property. Go back to my... And so we talked to them just to see if anybody had any objection. I think that's what triggered, or perhaps the city's notice for Mr. Grace. There was no response from Mr. Lee, who's this property right here. This property, the gentleman who owns that, the second one in, we talked to them and they had no objection. They weren't interested in writing a letter. 507, which is the one next door, that's the one that just sold. And there was no objection provided to the variance application from them either. You know, other than Mr. Grace with his concerns, because I don't know that I would call that an objection, you know, nobody seemed to have any qualms with the variance application. So moving forward with the application itself, as was stated by Mr. Janis, this property was originally one lot, and it was partitioned in 2008 to the two lots that he described, and it was surveyed and approved by Terry Sullivan and recorded, and the two lots are split with the two deeds. What's significant, as Mr. Janis pointed out, is at the time it was approved and recorded, the side yard setback was 10 feet at that point. And then that changed in 2014, which is when the larger lot rule came into effect. I went back through the minutes on that, and there was a pretty robust discussion back in 2014. And one of the things that came out of that discussion in the minutes was that there was a concern, or there was a recognition that this rule worked well for what I'll call regularly or typically sized lots. If you had a rectangle or a square, or frankly a lot that had parallel sides to it. There was a recognition, there were two recognitions actually. How would this affect lots that were in the pipeline or lots that had already been built upon? At that point there was the recognition that they would be grandfathered, but there was also the equal sort of realization that when unique circumstances came up, there would be a relief valve, which would be the Board of Adjustment for lots that, you know, aren't the typical rectangle or trapezoidal or, you know, having parallel lot lines, you know, in the front and back and side to side. I don't know that with the rule going forward that was designed to address, you know, sort of bulk on a large lot, that they wanted to not adopt that rule without the safety valve for an irregular or triangular shaped lot like this. So with that in mind, moving forward, and the property was never developed, my clients got the property under contract. They're moving here from up north, and Ms. Roccanelli's sister does live here. They want to be close to the family. This is going to be their permanent home, their retirement home. At that time, they did perform the due diligence that you would hope somebody would do at the time they purchased a property. They did get a new survey, and they worked to design the home. Initially, everybody thought, based upon the survey that I have up here, that the setbacks were in fact 10 feet on that side. But as they got further into the design of the building, and talking with potential builders and designers that are familiar with the rules, they realized that they had a side yard setback issue because the side yard was not 10 feet. And for the record, I want to point out that I was not the attorney that did that review nor that closing. So, won't say who, but it wasn't us. So moving forward, this lot is not in the shape of a rectangle. It's not even trapezoidal with parallel lines. So if you could slide back a little bit. Thank you. So the front boundary, as Mr. Janis mentioned, is 80.65 feet in length. However, the rear boundary back here is only 18.84 feet in length. As I mentioned before, with regard to Mr. Grace's letter, it's not even enough for a rear yard setback. The 10-foot rear yard line is actually closer to the back property line than the conversion of the two side yard lot lines. And as I mentioned too, I think if this was a lot that was more rectangular in shape, with the boundary of State Road more parallel with the opposite boundary, we might be having a different conversation here today, but that's not the case because it is a triangle. I think it's, to give it again some perspective, if you have a 5,000 square foot lot, which is the standard lot in Rehoboth, with the aggregate setbacks where, you know, it's 16 feet, you end up with 34 feet of width of buildable area down the middle of that lot. On this one, if you roughly scale it based on the side yard setbacks, you don't get to 34 feet even, which is the standard lot sort of buildable width, to about here, because it's so narrow in the back. So, you know, here's the point at which it's 34 feet, and that's the same point at which you get to about 50 feet wide on the lot itself. So from here back is actually smaller in lot width and in buildable dimension than even a standard lot in Rehoboth, which really, I think that's significant if you think about the intent of that original 2014 code amendment. It was designed to prevent, you know, bulk larger homes built to the setbacks on 10,000 square foot lots or 7,500 square foot lots in the city. This one, while it's 80 feet at the front, it's 18 in the back. So really, it's in this case, it's a penalty because again, you don't get to even the 50 feet till you're halfway through the lot itself. And I would add too that, which I'll get to the character of the neighborhood, but when you go back through the minutes, that, you know, the purpose, partially anyway, for that ordinance was so that properties wouldn't impact the light, air, and, you know, and again, the bulk in terms of, you know, properties within the city of Rehoboth. And what I would say, even like mid-block properties here, we don't have those concerns because this isn't a mid-block property. There's nothing to the left of this home at all. There's State Road and then there's the canal. And there's nothing to the bottom of it either because there's the city's pump station. Maybe, Ann, if you could, I'm giving Ann a workout here this afternoon, if you could zoom in on that a little bit. So Mr. Capone mentioned sort of the standards that we need to show or that are relevant for the board to consider on something like this. And it's the nature and character of the location. As I said, this one is unusual, thanks, Ann, for the city. It's bounded to the east by the residential properties, but that's where that new home's being constructed. And this shows it as being vacant, just because of the age of the aerial photo. But that's what's to the east. There is the Delmarva Power and Light Company property to the north, or on the top of the page, and then it goes residential above that. But what really makes this one unusual, aside from the shape of it, is that the western boundary fronts on the triangle intersection of State Road, Lee Street, Roosevelt Street, and the small connector road. The connector roads, yeah, there we go, that one right there. It's a triangle intersection. There's no homes there. There obviously never could be any homes there, you know, but it is all open in that area. And then further to the west of that is the Lewis and Rehoboth Canal. I think there's an Army Corps of Engineers easement at the top of the bank of that canal, between the canal and the edge of the road. And then it doesn't show up on here, but this driveway right here actually runs to the city's sewer pump station, which is diagonal from this lot. The other thing that's a bit unusual on this property, given the nature of it, when I went through it, there's no signs that say no parking, but there's physically no room for parking on State Road. There is some, I guess, in the front, although the pavement on Lee Street is narrow enough that there's not a lot of room for parking on Lee Street. You can see where people have actually further up here, it looks like paved their front yard a little bit to get off-street parking. But in this case, because there's the intersection here, and I didn't go look at the rules, but you can't park right up to the intersection for safety reasons. So that impacts the design of this lot because, you know, you need to figure out a way to put more off-street parking on the lot, which they have done in their design. And that pushes the house back, which in turn kind of jams it up the way the triangle's shaped and the way the two current side setback lines start converging as it goes towards the point at the top of the lot. Sorry, Ann, I'm jumping around again. So as I mentioned, they have designed a custom home for this property. It has to be custom. It's not one that can fit within the sort of cookie cutter FAR and lot coverage rules that most homes are built to, because this is most certainly not a cookie cutter lot. What I think wanted to show with this is that the bulk of their home is going to comply with the increased setbacks. One of the things that the courts look at for variance applications is, are you maximizing the need for the variance, or are you trying to keep the variance to a minimum? And here, at least it's my argument that we are trying to keep the variance to a minimum. Even though it really puts the squeeze on the property, there's only 4 points that jut out into the variance, into the side yard. So there's this one back here, right here, this part. There's a concrete or covered patio, not concrete, covered patio here, and then this corner here. But conversely, everything in the center is actually inverted, so that there's going to be a greater yard in the middle of the house, which you also don't see much in Rehoboth. And I'm told that Mr. Falcone is quite the gardener, so I suspect there's going to be lots of vegetables and different things grown within that interior courtyard. So, but the point is that with the design, they've attempted to minimize the impact of the variance so that it's not one great big wall running down the side yard. And because it's broken up like that visually, it's not going to create the impact of encroachments like a long wall or a big square house would be. So going through the standards, this is a unique lot for the reasons stated. It's a triangle. That note 2 of 270-26A puts the squeeze on it because it's a triangle. There's no parallel lines anywhere in here. There's only one right angle. So those calculations don't work like they would for just about every other lot in the city of Rehoboth. They really do create a hardship because it makes a lot really difficult to design a home on and build on with the way in which the back half of the lot doesn't even conform to the standard lot sizes in the city. It's not even 50 feet wide halfway back on the lot. Also, it's not a situation that was created by the applicant. It was approved with the 10-foot side yard lot lines, and then the rules changed. So again, what we're asking for is a variance from the current rules, but minimizing the effect of that variance on the current rules. The setback along, or let me go back, there won't be any impact on the neighboring adjacent properties or the area in general. As I mentioned, there's no homes at all there's nothing at all on the side of the property where this variance is being requested. There's no buildings, there's no homes, there's no other structures. There is the one to the north, as I said, which is Mr. Grace's property, but that's insulated by the DP&L property. Plus, on the DP&L property, it's pretty heavily vegetated up on that side, so it's not something that he will see. And even so, we're still further off his property line than we would be if he was right adjacent to this property. The setback along State Road will be at least 10 feet at all points, which is 1 foot larger than the 9-foot setback, which is required for the standard 50 by 100-foot lots. As I said, there's no impact on the neighboring or adjacent properties. I hope the city won't mind the variance request on its pump station property, because that's the only one that really will have a view of it. I would say the canal, as you know, the canal is actually below elevation, so people even on the canal wouldn't be able to see the property. As I said, it's mid-block, so it will not create the appearance of bulk. It will not affect anybody's light or air on an adjacent property, since there are none. And again, because of the nature of the home design with the broken up side facade, it will not be visually apparent from the road that the variance was even granted. The flip side of it is, will a denial of the variance have a significant impact on the applicants? And again, the large lot setback calculations that work really well for a rectangle make a triangular lot like this nearly unbuildable without the variance. As I mentioned, it really puts the squeeze on about half of this property. And as I said, it's not even 34 feet wide, which is the standard buildable envelope on a regular lot, until you get almost to the back of the covered patio, as shown on this survey. To give a little more perspective on measurements too, with the current setbacks, the buildable area, it only becomes 20 feet wide, not even the 34 that most lots are. It only becomes 20 feet wide at a point that is more than 50 feet from the rear lot line. So at this point, under the current setbacks, that's only 20 feet wide. And so again, if you think of a 50 by 100 lot that you have 34 feet of buildable area, that brings you somewhere out to here. So again, I just point that out that it gets the large lot calculations, but it can't even do in many respects what you could do on a standard lot in Rehoboth. So with that in mind, we'd ask that you would approve the request for this variance. Again, we're not asking for a variance to run down that whole side property line. We're asking for the variance as described in the application, just so those corners of the building as shown on the plan can exist and my clients can build a reasonable home on their property that meets the spirit of the code, if not the actual letter of the code, but will be an asset to Rehoboth. The other thing is that, this is a fairly prominent corridor in Rehoboth Beach. If you're coming in the back way, this is how a lot of people come into the city of Rehoboth Beach. So with this unique custom home that doesn't have a large wall running down the side, it has the broken up facade, and it's going to have nice landscaping. I feel like on this lot, it really does enhance the neighborhood and enhance the entrance to Rehoboth Beach. Without the variance, you would get sort of the Flatiron building that's, skinny at the back that I don't even know how you could put furniture in for the rooms. You'd be pushed back on a lot like this one is, because as you can see, the off-street parking in the garage pushes the front of the house pretty far off of Lee Street just because there is no parking on that corner. So it becomes really difficult to build a home on, if not impossible to build a reasonable home on this particular lot in the city of Rehoboth. It is truly an unusual situation. It's an unusual lot. I did a sort of an overhead view of the city and its lots, and I'm sure there's lots like this, but they're few and far between in the city of Rehoboth. And it's, the very type of situation that the Board of Adjustment, it seems to me, should review and grant relief on. So with that, what I'd like to do is, Mr. Chairman, I ask Mr. Falcone and Ms. Roccanelli if they could be put under oath just to confirm everything that I have stated.
First, we're going to go one at a time, so if there's any questions, it would be...
Get up.
You needn't get up.
Sorry?
So it's Ms. Roccanelli?
Yes.
Is that right?
Linda, yes.
Do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yeah, okay. I wasn't sure if you were doing both. Okay. Ms. Roccanelli, you have heard everything that I've stated to the board this afternoon. Do you agree with all my statements to the board?
Yes.
Okay. Is there anything you'd like to clarify or add?
No.
Okay.
I think you've stated everything clearly.
Okay, thank you. And if we could do the same for Mr. Falcone.
Sir, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And same question, Mr. Falcone, you've heard everything I've stated this afternoon. Do you have anything, or do you agree with what I've stated?
Absolutely.
Okay. Do you have anything that you would like to add or clarify?
No.
Okay.
You've said it all.
All right, thank you. One thing that did come to mind as I was going through that, and Mr. Janis raises a fair point in his report, we have not applied for a building permit. The designs and survey have been, and we actually have elevations too, but I just didn't get into that, but they've been designed to be essentially permit ready, but it wouldn't be appropriate for us to submit the building permit knowing we need the variance application. And I think he would agree with that.
But the question is, you do have plans drawn up so far?
Yeah, no, and I can show you. So, and to answer your question, so it makes it not speculative at all. There's plans. I think that maybe was where you're on. So this is the front of the house. Maybe, Ann, if you could zoom in a bit. So that gives you an idea what the front is. The left-hand side elevation is here.
This is the elevation facing State Road.
Yeah, and it's a little hard to follow that because it doesn't give you the depth of the various points that we're talking about. But, you know, so this would be the front of the lot over here with the garage building in here. And then sort of in this is the covered patio. And I say this, obviously we've got to go through Mr. Janice's, you know, approval process for building permits.
So this looks like it's a two-story house, only perhaps 50% of the footprint is a two-story.
I think that's true, yeah, because this in here, the center part, that's where that interior courtyard is, where the home, I would say juts in, that's probably not the right word, but if you go back and look. And maybe if you could slide out a little bit. Oh, move it up. Yeah, I was going to try to show both at the same time, but so you can see how it goes in. That corresponds with roughly here.
All right, I have a question at this point, and I'll address it to the three of you.
Okay.
So I certainly understand and better appreciate now that I've seen these plans, the way the house was designed to kind of break up the long lines that were involved in that lot. But where do you picture doing your outdoor living in this, on this property?
In the center.
On the center-facing State Road there, there's
Correct.
kind of like a little courtyard.
Yes, we were hoping to put a small pool in that small
All
area.
right, so then when you say pool, you talk about fence.
Yes, absolutely.
All right, so now you've designed a property to focus on the angles to break up the line, and now you're thinking about a fence. I'm wondering where you picture the fence being and how tall you imagine the fence being.
Well, I would imagine that the height of the fence has to comply with what,
Well, there is a little, there's a minimum and a maximum, okay? So the minimum is 48 inches for the fence, maximum 6 feet. Okay, so if we could look at your plot plan, your
The larger one?
house placement plan, where would you envision this fence going?
And Mr. Capone, if I could,
on,
oh, go ahead.
okay.
I was just going to say, and I don't want there to be any misconceptions, we're not coming in asking for a pool. I'm not sure whether down the line a pool will fit or not with the FAR and everything else. So, you know, I don't want you to think that we've applied for something we're not showing everything at this point. So,
Well, let me ask you this. So you're not here today thinking that if we were to grant your variance, we've granted you a variance to put a fence.
no, that's correct. So, and we hadn't actually talked about that, Mr. Capone, but you know, at this point, we were looking at the variance for the property corners of that building because, as I said, the setbacks on this property for the home, that's a showstopper. You know, I mean, you can't build a home on this property. Yeah. Depends on.
May I ask a question to maybe clarify here?
Hold on a second.
Mm-hmm.
All right, so the point I was trying to make is, we're not here today putting ourselves and yourselves in a situation where you think you've got a variance for a fence when you don't.
Well, we had focused on the corners of that property, and, you know, and what we're asking for is a setback variance. So to the extent that that would cover a fence, I assume it would. But as I said, we're focusing on the house at this point because that's what the plans have shown.
Right, and
I don't. Let me put it this way: I don't want to preclude coming back, depending on whether we can fit something else in there for another variance.
okay, so if we were to approve it, under one scenario, we could approve it with these plans, but there are no plans for a fence here. And if at some point you decided you wanted to come for a fence that didn't conform with the required setback requirements, you'd have to come back for another variance at that point.
It would depend on how you grant the variance. I mean, because we've asked for a setback, and I'm not trying to dodge it, but we've asked for a setback variance. We've talked about the house, but it is a side yard setback, so it depends on what your decision is from the board.
All right, well, we may be able to come up with wording that makes it clear for all parties. Let me see if I had any other questions.
Because I would say, Mr. Capone, here's the issue, and I realize that there are height issues with a fence, and this one is a corner lot, and as you know, we've had a bite out of that apple recently. But at the same time, just to your question a moment ago with the fences, I'm looking at this site plan. If we don't have a fence, I'm just going to use this. It makes just the side yard, given the nature of the lot, it does the same thing as what we talked about with those side yard setbacks. That makes the point at which you could put a fence. So it really, as much as it cuts off the building, it cuts off even usable space on the yard because of the penalty, I would say, based on this lot being a triangle. It goes from here, which is every other lot, keeping in mind that this is the point that's 50 feet wide right here. It goes from there all the way to here. So now you've got the permissible location of a fence halfway down the interior of your building, and to your point, given the nature of this property and the size and shape of it, it makes even the yard not usable.
Well, I'll differ with you on that because the yard's usable, but it can be usable without a fence. But
and I guess go ahead.
So my point is this: when I looked at this, I saw a house that I thought that had been designed with care to make it attractive, considering the layout of the lot, the long lines that otherwise would have been could have been used, and so in that respect, I go, well, this is a pretty nice design we have here. But if you were to put a straight fence, from one corner to the next, then you've kind of pulled back the advantages that you presented it today by showing us this nicely angled house. A fence would kind of minimize that or obscure the angles to a large part.
Well, and I hear what you're saying, and as you mentioned earlier, there are fences and there's fences in terms of height, there's a question of whether it could be a 6-foot fence or a 42-inch high fence. But I think there's another justification for why it makes it appropriate to allow the fence to be at the 10-foot line, the same as the variance you're requesting, because of the location of this property. This is State Road. It's the main back entrance into Rehoboth Beach. It's actually the way the DART bus is used to come in and out of Rehoboth Beach. It's got a lot of vehicular traffic there. And to Mr. Grace's point, there's actually pedestrian traffic to some extent there, not a lot. I would say it's more local traffic, people walking than, like tourists or visitors. But, that I think in and of itself supports the ability to put a fence to the extent you all want to impose a height restriction on it or a type so it doesn't become a wall, because that runs counter to what we said about a wall. But that, I think, is justified in this case because of the location of this lot versus having it here, which basically then exposes all the parts of that building to whatever, and it doesn't create any sort of barrier from the road and the traffic on that road and bikes and everybody else.
Well, I can see what the concerns are. I mean, I walk that route, a couple of times a week, so I'm familiar with it. But the fence could be an issue. There may be some members of the board who would be concerned about granting a variance that included the fence. Some members of the board might entertain a motion to grant a variance based upon the building, what do you call in this document? The house placement plan, which does not show a fence. You understand what I'm saying?
Yeah, I do. I mean, it just strikes me that, a setback, is a variance is a setback variance, you know, and most often when somebody builds a property, you know, a lot of times, you know, your backyard or your side yard, that's sort of an afterthought. You know, the main thing is to get the home placed so that we know what we're asking for in terms of the placement of the building. But I think, you know, I don't want the board to think because there wasn't a fence that was asked for on here that, you know, that wouldn't be included in the variance, because that really goes to the heart as much as the house, secondary to the house or ancillary to the house, to the reasonable use and enjoyment of their property, to have a fence that coincides with what we hope you'll grant for these variances, you know.
Well,
so
there may be some members of the board who would not seek to preclude you from coming back at some point if you wanted to seek a variance for a fence. But we'll see. We yet have to vote on this, so this is just one subject that came up.
And I will add too that, as you know, and the board knows, the type of fence you put in depends on what it's going to enclose too, you know, because if there is a pool, that dictates one kind of fence, and if there's not a pool, that potentially dictates another kind of fence.
True, and that's one of the reasons why I read this lady's letter at the beginning of this meeting today, and I'm not done with it yet, but that's the reason why I wanted to discuss that letter. All right, I think I've asked all the questions that I have. Anybody else have any questions? And I think you do.
Yeah, and I do also.
Okay.
I do. I have two different questions here. One is.
This is Randy Mason speaking.
Is the request that we're being asked to give for the entire setback, or is it just specifically for the structure that is being shown that has not been requested? That's just not, I mean, that's what I.
That's related to what I was just talking about.
But I'm wondering about, you know, in terms of the process and what has actually come in, what does the request specifically ask for? If it's the side yard setback, to me, that means the entire, along that entire street. And then they wouldn't necessarily be coming back for a variance because we have the setback that's been granted for the entire space. And I guess what you're suggesting is that we might consider sort of amending or just granting a certain portion of that.
Granting a variance for this structure that they proposed.
Okay, and that's the question. Is the variance for the structure, or is the variance for just the side yard setback of being 10 feet all the way up and down? That's what I'm confused about.
So we're in a bit of a chicken and egg thing on that, quite honestly, because, you know, Mr. Janis, I don't think he would review plans that needed a variance if we didn't get the variance for, so which is why we're here today. So, I mean, I'm representing to you that this is their plans for the home. You know, I can't quantify, you know, each point where it encroaches into the setback to make it that specific. I also don't want to be so specific that we say it's this exact house. And I'm not trying to be cute with that, but when it goes through the permitting process, you know, there may be tweaks to the design plan, you know, given the back and forth with Mr. Janis. I mean, they have spent a lot of time and money to design this house, as I hope you all can see. You know, we're not going to do a bait and switch, but, you know, by the time Mr. Janis reviews it and looks at, you know, the structural components and everything else, is it going to be exactly like this? You know, I don't want to go on the record as saying it's going to be 100% this house, you know, when it may get some tweaks along the way. And I'm not trying to complicate things. I just don't want to get boxed into a corner where Mr. Janis says this is different, and we've got to come back to you all for another variance on the house.
Dawn, you have another question?
Sorry,
Yeah, my other question is, looking at the lot lines and the iron pipe, it appears to me that there is city property that is owned between the edge of this lot and the street. Do we have any idea how much land that is there? I mean, I'm guessing it looks like about 8 feet, but I'm...
Between the property line and
Between the property line and...
Scaling it, it looks like it's about 8 feet along State Road, and then it's obviously a little more along Lee Street, but I think that's about right. Wouldn't you say, Matt? Yeah.
Yeah, I would agree that it's probably around 8 to 10 feet,
Yeah.
depending on.
It's 9 feet 8 inches, it's on here.
Vertical, and you got the property line.
You see a measurement?
Well, it looks, Randy, like it's 9 foot 8 inches, because it's kind of a little block right here on the corner. You know, I mean, the paper,
Okay.
but it says 0.8, and then it points over there. My assumption has always been that that is the city easement along there. Is that correct? Because it's just
Right
about
of way.
10
Well,
feet.
let's figure out, so anybody want to address those concerns?
I think that's roughly true. I didn't see the same block, but that's about the same width, and it's actually not an easement, it's owned by the city. I mean, everything outside.
I'm sorry,
Yeah,
I have
right.
the same thing in front of my house. It's
Yeah,
owned
yeah.
by the city.
Right,
Yeah.
right.
By the city, okay. So
It's
that-
all part of that right away.
So that the lot line is set back from the street, basically.
That's correct. So in this case, so actually, thinking this through a little bit further, from the curb, the edge of curb to the corner of these structures is at least 19 feet, which is the side yard variance setback that we're asking. So I want to take that a step further. If this was an interior lot that was next to another lot, not city property, if it was next to another lot, there wouldn't be that additional 9 feet between the curb and the property line. There would just be a property line. So here, we're getting the 19 feet of apparent setback that we would be getting if it was, or wouldn't be getting, I guess, if it was an interior lot within a block in the city of Rehoboth.
You have any other questions, Randy? Walt, you
That
have
was
any
my,
questions?
that was my question, was between the property line and State Road, who owned that and how wide that was. So that was
Jan, I
answered.
think you have some
Thank you.
questions.
Yeah, it looked like it to me. I can't tell 100% sure, but it looks like a 9 feet 8 inches. And I can't tell on this map what it is on Lee Street, what the city easement, or city property is on Lee Street.
Looks like it's a little larger.
Yeah, and Ms. Conacy, I'm looking at, and I don't know if it looks like what you may be looking at, there's a storm drain, it says the invert on that's 9.5 feet, and that's actually an elevation. I'm right here. Is that?
I have no idea. I'm not a
Yeah.
really good map reader, but I've just looked at this little line here, and I know that typically the city property is 10 feet,
Yeah.
more or less, and I saw 9 feet 8 inches, and I thought, well, that must be it.
Yeah, I think that's probably about what it is, maybe a little bit less, but I think, Matt, isn't that, I haven't spent too much time doing county sewer stuff. I think the rim is the top of the storm drain, and then the invert's 9.5 feet. That's an elevation thing, not a width.
That is correct. That's for that structure only and not for any dimensions for the setbacks. And with my my professional scale here, I've determined that it's roughly, as it goes around that corner, it's roughly about 9.8, and as it goes around, it decreases a little bit, but it's a little bit more than 9 feet as we round that corner.
Okay, and what is it in front of Lee Street, on the Lee Street side?
It looks to be roughly about 12.
12, okay, okay. All right, my question then was, when was the property purchased by the applicants? What year?
I can tell you because it was on the deed. Bear with me.
December 30th,
Yeah, as I say, they can say as well.
December 30th, what year?
2020.
Yeah.
Questions, Jan?
Well, I guess what shocks me is that when they bought this property, neither the realtor or their attorney told them that there would be restrictions on building on that piece of land. I'm absolutely shocked to hear that, that they would not be able to build a 3,000 square foot house with 250 feet of front porch because of the shape of the lot, and that it would require variances. That's all.
Do you think, though, I just want to make sure that you're not, that your thinking is correct. Are you saying, or are you thinking that because they purchased it after the partition, they are at a weakened position because they should have known that?
Yes, actually I am.
Okay, so.
These aren't $20,000 lots.
So maybe somebody screwed up, but do you think that they have less right to make this argument than the previous owner?
The guy who sold it to him,
Right.
or the person, the LLC who sold it to him?
Let me ask you this. Do you think that they have less right to make this argument than the person who partitioned it?
Yes, I do.
Why is that?
Because when one purchases a property for, multiple hundred thousands of dollars, one would hope that their attorney or their lawyer would have said, there are limits to what you can build on this property, which might be why it's not.
I'm going to toss this to council in a minute, but,
Okay.
but my understanding is that when you buy a property, you buy it with all the rights that the owner who sold it to you had. So if that owner had the right to make a certain argument, you acquire that right when you purchase the property. You don't acquire less than the owner did, which is what I think you're thinking. I think my position is correct. I think it's the McGovern case is the case I'm thinking about, but I think I'm right. So, but that's a
So-
legal issue.
Okay, so what you're saying is, if there were restrictions on the property when it was partitioned, right? And you could build a 10-foot setback in your backyard instead of a 15-foot as now required, and that there were no restrictions on large lots, that those carry over for the lot ad infinitum, or just to the next purchaser?
No, and anybody, whatever rights the owner had, the seller had, you acquire. Okay, so if he may not have had the right to have the variance granted, but he had the right to make a certain argument from his position. Hey, when I bought this property, I thought that it was going to be, it only had 16-foot aggregate side yard setback. Okay, so therefore I should be entitled to use that setback. I'm arguing that at least I think that these sellers are entitled to that same presumption. I think there's case law to that effect.
If I could reply to that, and I didn't want to go off on a tangent on this, but because the question was raised, I do want to get it in the record for my folks. When they bought the property, they wanted to make sure, to Ms. Conacy, to your question, that it was buildable to this house that they wanted to build. Well, I mean, they designed it, but they knew in their mind what they wanted to build. They requested that information from the attorney. They actually went to a surveying firm to get it surveyed so that they would know what the setbacks were. And I think Mr. Capone makes the point that everybody has the ability to apply for variance. They have no less of the right to apply for variance than anybody else.
I agree with
Right.
that.
And they were hoping they wouldn't have to apply for variance based on the house that they thought would look nice on this property and would fit within it. The survey that they got shows, back in 2020, shows a 10-foot side yard setback. So I don't know how relevant that is, but the backstory is they did everything they should have done to get to the point where they could build the house that they wanted. They relied on all these other design professionals, got to the point where they were ready to basically start bidding out the home. I mean, because this home would have probably been under construction already, but they had to hit the brakes and come here and get a variance because turns out what they were told was not correct. Again, I don't want that to be too much of a red herring because I still think that because of everything we talked about with the size and shape and the uniqueness of this property, that it justifies the need for a variance, probably more so than, as I said, just about every other lot in Rehoboth because of the way it's weirdly shaped. But I also don't want you all to have the impression that they didn't do their homework, because they did. It's unfortunate that we're here today, all of us, but that's where we are. I don't know, Mr. Falcone, Ms. Rognelli, if you want to add to that.
Do you have any other questions?
No, but what Vince is saying is that they have a right to build a house on the property, and they have a right to ask for a variance, but not to build exceeding what the code is now without a variance.
I agree.
Okay.
I agree with that, but I think that they are in the same position as the person who owned the property ahead of them, who said, when the parcel was partitioned, we only had 16 feet to setback aggregate to deal with. I mean, I could conceive that they may have moved the property line in one direction or the other if they would have known that there was going to be an increase in the setback. So I think that they have an equitable argument to make. What the strength of that is, it's up to us as individuals. But I don't want anybody on the board to feel that they have a lesser argument than the person who owned it at the time it was partitioned. That's what I'm saying. Okay? Yes, sir.
Ask a question of
Yeah,
Mr.
sure.
Rock? So we've heard a considerable amount about how this lot differs from typical lots. I'm trying not to use the word unique, because I don't think that that's a favored term in this circumstance. But we've spent a little bit of time looking at the house and heard a little bit about it, but I think it would be important for the board to hear a little bit more about why those areas that are non-compliant with the existing setback are necessary, why they're desired. And if you were to scale this and to the point where you had a much larger lot and a much larger house, the argument might be, well, you don't need a house that large. So where's the need created in those areas there, as opposed to just a desire?
Sure. Maybe, Ann, if we could scale it back a little bit, and I'll let Ms. Roccanelli maybe speak to this too, but Ann, if you could zoom out a touch. So let me start with one thing, first of all. If this was a rectangular shaped lot that had the 80 feet of frontage, that we're talking about, which triggers that large lot setback calculation, and you do the parallel lot lines, we don't need a variance. Because the thing is 80 feet in the front and 18 in the back, that's what we need a variance. So every other lot that's large in the city of Rehoboth Beach that's got parallel lot lines on the side, we're not asking for a variance. And frankly, if you did that, you'd be building a whole lot bigger house, I'm sure. Where we get into the need for it, and obviously I'm not an architect, I wasn't involved in the design of it. Perhaps Mr. Falcone or Ms. Roccanelli can explain this, but there's several limiting factors on this property, as I mentioned. We've got to get off-street parking off of Lee Street. And more than really just 2 spaces, because you can't park anywhere on State Road and you really can't park anywhere on Lee Street. So that basically shoves the house back and pulls the garage in on the front. And if you shove the house back, then that sort of moves everything behind it into those setback areas. This is a larger garage than we see. Frankly, we don't see garages very much in Rehoboth all the time anyway, but part of that is because we need to shove the house back to get that off-street parking. And then if you have a garage, and you can't invert the garage, that's the other thing. We can't put the garage in the driveway over here because you can't, I'm sure Mr. Janis would say he doesn't want the curb cut here, and I think State Road is, it actually is a county road, so that's a Del Dot road. Del Dot's gonna make you put the entrance all the way over here. So if you have the entrance over here, that basically shoves the house over this way. And if you have the garage here, then you've got to have something in the house behind it to have access to the garage. And then from there, everything is loaded over to the other side of the property. I go back to, and I did the same thing as Mr. Janis, his handy-dandy scale. Mine's ink pen on a piece of paper. When we're back here by this tree, that's only like 20 feet wide. I mean, so if you get to the point where if you don't have a variance back here, no matter what that interior space is, you've got like a 20-foot wide, piece of home that's sticking out that's got to taper off in the back. So it really makes it difficult to have any usable interior space in that regard. So I don't know, Ms. Roccanelli, if you wanted to add anything.
That's the master bedroom.
Okay, yeah.
And, yeah, right, that would be going right through the bedroom.
And the fact of the matter is, I will say, knowing enough about design, that given the location of this property on State Road, you would want the master bedroom in the rear of the property that's away from the city's pump station, although the city's done a really good job filtering the pump station, plus that, hold on. Ann, if you could zoom in on that. This major intersection, which is State Road, I'm pointing, but down here is the Highway 1 bridge over the canal. So you go this way, it goes to the school with all the school buses. This way is the DART bus traffic. Everybody's coming in and out of town in Rehoboth that way. So going back to that design, that's where you're going to want to put your master bedroom, so it's furthest away from that intersection.
If you wouldn't mind putting up the side view of the property from State Road once again.
Okay. Bear with me, Mr. Capone. And so, looking at that, I'm going to just use this one real fast. I talked about the driveway in the front. Del Dot's more than likely, because of this intersection, because we're not dealing with the city on a curb cut at this point, we're dealing with the Department of Transportation. They're not going to let us reverse that house and front load the house this way and put the garage back here and have it come in and basically go into here, because they're not going to want that curb cut that close to that intersection with State Road and Lee and coming in the back way.
State Road, they wouldn't allow it.
Okay.
The reason why I asked you to post that, and the question I have is any portion of this two-story building and in the setback, and I'm guessing that's the two-story section on the left of the property.
Do you mean in the building envelope?
In
The existing building envelope or in the relief area?
in the relief area.
Yeah, and if you could zoom out so I could show both of these, that might help. Then you'll sort of see, well, let me do this. If that sort of, I'm in if it, oh no, that's not it.
Then turn it sideways and put it over Linda's name.
Oh, I see something like that.
Yeah, there you go.
Hold on.
Maybe even turn it the other way.
Yeah,
You can
and
see
flip,
for the view from
Oh,
Lee.
like that?
There we go.
that's it.
Maybe if you want to zoom.
That's great.
Yeah, I see it. That answered my question.
What square footage is it?
All right, are there any other questions from board members? All right.
Yeah, I have a question.
Okay, go ahead.
What's the square footage of the house and the garage combined?
I believe it was 27 or 28. I don't know exactly.
What, is it your testimony it's under 3,000 square feet?
Yes, it is.
Okay.
And the reason we have the second floor is because of the shape of the lot. We couldn't put 2 bedrooms or 3 bedrooms on the first floor. That's why, and I don't think having 1 bedroom in a home is enough. That's why we went up for 2 other bedrooms.
How many bedrooms you got in the house?
3.
3. Very nice.
Mr.
I
Cap-
wanted 2, but
And that
I was
includes the
outvoted.
garage.
They initially designed 4,
Not
so we
enough, believe me.
on 3.
And I'm, Mr. Capone and Ms. Coniston, I'm looking at the plans, and it looks like it's under 3,000, like we said.
It's either 28
Yeah.
or 27.
And that includes the
change.
garage and the
Yeah, 'cause it
outbuildings
talks
and
about
everything.
And
1,958.
the basement is not included because of
Chair,
the
she's
height.
having a really hard time.
Yeah,
Yeah.
Can't take 2 or 3 people.
Right.
Oh,
we-
okay, sorry.
Just one at a time, please. You wish to add to your,
Oh, I'm
remarks?
sorry. Yes, we do, a portion of the house does have a basement, but it is not considered livable space because of the height of the basement. So that was not included in the square footage. That's how it was explained to me. Is that?
We understand. All right, any other questions from board members? All right, so now I think we're at the part of the program where we invite people to speak from the public. I see a hand raised. Tom Evans, would you come up, please? And Mr. Counselor, would you swear Mr. Evans?
I hope so.
Oops.
Mr. Evans, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I so affirm. It's actually short for me. That's unusual. I had tons of notes, then I had short notes, now I have more notes. I just want to say one thing first. I'm a 35-year resident of the city of Rehoboth Beach. My wife's a lifelong resident of the city of Rehoboth Beach. I served on this board for 22 years. I'm not a newbie to town, nor to people doing due diligence, and I can appreciate you sometimes believe what people tell you. But I'm going to start with the part that I don't want to forget, which are in my notes, not in my bullet points, which is probably out of this the most important thing I heard today, which is depending on how the motion is made and how you vote, this house may not be the house that's built. You'd be granting relief for the setback, but they could maximize to whatever's legal without needing another variance. Be aware of that. So you're playing games with hearsay and not true evidence or facts and evidence, not having a building permit, nor really bona fide drawings for what's going to be built. You'll give relief for the corners as you see them and a setback, and you have to deal with everything else downstream. I'll do my bullet points and come back to the notes around them at the end. And they're still all applicable, even though I've heard both Mr. Robertson and you all mention certain things. I've also heard more hearsay than I usually hear in a hearing like this. And before I'm done, I'd like to hear Mr. Townsend give us the evidence that your board chair indicated there was in statutes, in code, that would indicate what he said earlier, because he put that out in the ether without any evidence to his statement. I'm no offense, Jerry.
You know what? Go ahead.
Just go on. I'll take my time. Everyone is due the right of reasonable return on their property, not a maximum return on their property. The applicants should have known at the time of the purchase, and now we know that it's under contract. It's not even done. If I heard the hearsay from Mr. Robertson, no, you said under contract in one moment.
They own it.
Okay, you said under contract.
No, I did not. I showed the deed that says they own it.
I'm only saying what I heard at least once, just saying. So anyway, it's a recent purchase. It's not a long-term purchase. It certainly happened after 2014, which is the question I also had that Mrs. Connessy asked. So they had every ability to understand that this was an unusual lot. I'll use that word myself. A triangle lot is an unusual lot in common parlance. And then it might be difficult under any circumstances in any city code to build something that's conforming. And I have sympathies for that, by the way. I would probably be the last person to buy a lot that seemed to be a problematic lot unless I got it for a good price. After purchasing the property, they should accept the limitations of the lot as are currently in place. They are not due any variance to construct the house that they desire, as they create the need for the variance themselves by the desire to build a house that is bigger than that is allowed by the code. So you're right, they have a right to come for a variance, but they should have known, and therefore I believe that weakens their case. Other things that were said that I heard, and I can only say that I heard them, let me find one more, is that I've heard this repeated several times, both in writing and orally this evening, that this afternoon, that this lot, if they don't get this, they cannot build a house on this lot without this relief from the setback. That's simply not true. They can't build this house. So I take that as a clarification on what was said today. And I think that's my last note that I can at least read. Thank you.
Anybody else have anything to say? Are there any questions for Mr. Evans? Any other member of the public who wish to speak about this? No. Mr. Roberts.
Just one point of clarification, because I'll admit the fence kind of threw me a little bit, because we weren't talking about fences, but looking at the code, I think, and maybe Mr. Jansen can clarify this, they can build a 42-inch fence on the property line, because you're allowed to enclose the yard. So that could go all the way out to the property line. What we'd be talking about was whether they could build, a higher fence or whatever they may want to do. And I know I didn't answer that clearly earlier. I was thinking in terms of a fence is a fence is a fence, which, as we know, is not the case. So.
And the reason why I asked that question is because you focused. I mean, part of your pitch today is that this is like a gateway to the city, and you wanted an attractive house on a difficult lot to highlight this gateway to the city. But a fence of significant height, I think negates everything that you may have achieved by designing, this interesting house. So that's something I think the board needs to consider. All right, anybody else?
Just have one point.
Go ahead.
Walt can correct me if I'm wrong, but I believe that the maximum house you can build and have a pool on it is 2,800 square feet.
Might be a question to ask.
I'm sorry, 2,800 square feet, isn't it?
It's lot dependent size, so if you have a larger
because they have
lot,
a big,
Wait, let
Okay.
him finish.
if you have a larger lot, you could build a larger house, but there is a calculation involved again with a lot size over 5,000 square feet.
so they could still have a bigger house and have a pool too, because the lot exceeds 5,000 square feet,
Potentially.
potentially. Okay. I'm just, so there's an advantage to having a larger lot if you want a pool, but there's a disadvantage if it's shaped like a triangle, kind of. And the city doesn't take that into account when determining if you can have a pool. They just look at the size of the house and the size of the lot.
That's correct.
Okay, thank you.
Explain to me what
Would you like him to explain that?
Yes, please.
Go ahead. She'd like to.
What's your question, ma'am? Just to be sure.
My question is that there's a certain percentage, there's a certain size of a pool that could be placed on a lot that size.
So,
I'm not looking to put in an Olympic-sized pool.
Sure, I think I understand your question. So the construction is controlled by two calculations. One is, of course, lot coverage, which directly speaks to how much lot you can cover. The second is the floor area ratio, which says you can have this much house compared to this much lot that you own. You get restricted a little bit when you propose a pool in floor area ratio. You can build, essentially on a 5,000 square foot lot, you get penalized, not really penalized, but restricted to 500 square feet. So in a normal 5,000 square foot lot, a 3,000 square foot home can be built without a pool. A 2,500 square foot home can be built with a pool. And then the calculation comes into play when we have oversized lots greater than 5,000 square feet. You get a little bit more credit to the house, but not to the coverage. Kind of works itself out because you're still at 50%, but you do get decreased in size for the house.
Thank you.
No
Now
problem.
I understand.
Can I ask Matt another question?
Yes, you can.
Then how do you figure, if they get a variance to have a lesser setback, how does that impact natural area, floor area ratio, the location of fences? I mean, they seem to have not know all of these things. It might have been helpful to visit him before you bought the lot. But how does all that impact if they get a variance? Or do we make the variance so restrictive that it allows the house? But then what happens if they want to put a pool? Do they get to count space that we just allowed them to use?
So I think you're asking me, first of all, they're only seeking a side yard setback variance here. I don't believe it is because of the house, because of the structure, et cetera. They're seeking a side yard setback. The calculation goes to the lot size and not necessarily the building triangle. So it's your overall lot size, and then we look at the setback requirements that the code dictates.
Okay, so the lot size carries with them.
Yeah, so the answer is it does, the granting or denying of the variance doesn't affect the lot coverage in bulk that you were questioning.
Thank you, Mr. Johnson.
Are there any other discussion about this case? All right, we're at the point where we're going to vote. All right, is there a motion to be made?
I'll move that we approve the side yard setback as.
Well, is your motion to approve it as it pertains to this particular house, or to move that whole setback line to 10 feet, to the 10-foot mark. Do you understand my question?
Well, as I heard Mr. Janus just indicate, is that the application is for the side yard setback. And so it would be for the whole line is what I'm proposing, yes, that we approve.
All right.
Because a 42-inch fence, if we're going to talk about fences, can go on whatever setback would be there.
That's true, but I'm inclined not to, you want a second? Is there a second?
The code says the property line.
If not, then
What do you incline? What do you incline? I want to hear what you incline.
There not being a second, can we continue discussion? Okay, we deliberate. So, my concern is that by granting the setback, to move that setback line back to the original setback line from 2000, prior to 2008, gives them perhaps more ability to change what I've seen here today than I would prefer. I personally feel inclined to grant the variance to the extent it's depicted on that, what do they call it, the house placement plan. To say, if that's the way you're going to lay out the house, if that's going to be the footprint, then I would consider granting the variance.
Can we ask, before we have a motion, can we ask staff whether they have sufficient information in that plan to enforce such a motion were it to be, or such a variance were it to be approved?
Thank you, Mr. Townsend. I don't believe I do. I don't know any square footages, any lot coverages that are being proposed.
Oh, not lot coverage, just a question of, do you have sufficient information to know, not whether that house could be built, but whether where the relief from the setback restriction would be given the submission by the applicant? Are there dimensions on that plan that are enforceable?
I don't know if I'm allowed to speak or not, but I mean, it's detailed. I mean, there's points on there that shows, you know, how far off each point is from, yeah. No, they just want what's shown on here.
Yeah, I do not have plans, obviously, that would, that I could approve today, saying that this would be the only encroachment. And I would ask, obviously, as Mr. Capone stated earlier, that we're not nickel and dime these guys to death. We're coming back in and saying, all right, we have a variance for the building now. Now we need a variance for the fence. Now we need a variance for the pool. I think that could get muddy, obviously, as we go down through there.
You think what?
I think it get muddy as we travel down that path if we're constantly, you know, nickel and diming these particular applicants to death.
Well, I understand what you're saying, but I take issue with the term nickel and diming. I mean, we're here with what we're presented with, and we're trying to make a decision based upon what the applicants presented today. So you're telling us that this house placement plan doesn't provide you enough detail or dimensions to determine whether or not they've complied with a motion. For example, let's take a motion that said, the house layout must be built in accordance with the house placement plan dated 6/22/21, which was submitted to the Board of Adjustment as part of the homeowner's application. If that, you don't think you have enough of a footprint?
No, I would.
We just don't think it's sufficiently detailed with enough dimensional indicators to figure out exactly how much each of the encroachments are. I think it'll be very difficult if you adopt a motion that is limited to the placement plan that's been submitted. I guess my view would be the applicant has asked for a setback, a side yard setback variance of 9.8 feet.
Correct.
I think that's the answer. Do you give them a side yard setback of 9.8 feet or not, for whatever plan they ultimately come in with? They're in the unique situation, I think, that they had all this work done. Many times, I don't think the board would have this level of detail before it. And maybe in some ways it's helpful in fashioning a motion, which is what you're trying to do, to make it limited. And I can understand that. But I don't think that at this point, the building official is confident that he could enforce a variance that is limited to this placement plan.
Part of the issue with that is that, you know, as the board knows, and Mr. Mendelis knows, and I know from doing these, if we came in here with not a plan to show you, you all would say, well, that's speculative. How do we even know there's a basis for granting the variance? And I get that. But now you're saying, or the way this discussion is going, is that you're saying, all right, we showed you a plan for a building, but we have to design it to the point where it's ready for a building permit to be issued before you'll consider the variance. That's not logical either, because as we said before, and Mr. Janis agreed, he's not going to spend the time with his staff to study building plans that are permit ready if they're not compliant from the get-go. What we've done is what I think historically the board has asked is we've applied for a variance from the setback. We've showed you what the intent is. We're asking for the setback that Mr. Mendelis has asked for. You're putting us in a position of, I think, never being able, not even on the merits, but never being able to apply for a variance that you all will consider if we've got to design the thing to be building permit ready. On the one hand, you know, and you know, we've got to come in here with enough detail that you all feel comfortable that there's a basis for the variance. You know, we're back to, shoot, would we have been better off just coming in and saying, here's the big setback line, we need a variance all along it, you know? I mean, it seems like we're being penalized for coming in with a detailed set of plans to show that a lot of thought has gone into this, but knowing that at the same time we haven't submitted anything for a building permit with Mr. Janis's office, because rightfully so, he wouldn't consider it.
No, I completely understand that, but what you can, and I can see that it was a considerable amount of work done here, but what you came in with isn't exactly what you're planning, as far as I heard today. I mean, I'm understanding that a fence is going to be built and a pool is going to be.
No, we didn't state that, and I state, you know, right the opposite. We're not coming in for, these plans show no pool. I mean, there may be a fence along the boundary, which is permitted of 3.5 feet. I don't know what they're going to design with a pool or whatever, but if they are, we're talking about this house with this floor plan right here. I mean, if we were asking for a variance for a pool, it would have been on there.
Let's.
And let me back up. You know, we ask for variances all the time. You know, if somebody has bought a lot and there's a chimney or an air conditioner that encroaches into it, and you've got an existing situation, and you say, okay, we're granting the variance for this HVAC unit or this porch or this set of stairs or whatever. We know we've got a finite structure that exists, and we're granting a variance for that. When we're in this situation and we're looking at an irregularly shaped lot, and we're asking for a variance based on the uniqueness of that lot and the shape of it, and the fact that you know, these setbacks are superimposed on a lot that's not rectangular in shape, you know, we're asking for a variance for that 9.8 feet like we talked about because of all those circumstances, knowing that you all would say, well, what are we granted if we don't have a set of plans to look at? So we've gone a step further and provided you with a set of plans to look at. As again, I think, I don't want us to get penalized and my clients to have the variance denied because they've done exactly what the board historically asks for.
Some representation of what is desired by the owners is necessary to evaluate whether there's an actual exceptional practical difficulty. So we need some kind of foundation for making that judgment, and that's incumbent upon this group to make a judgment like that if a motion to grant a variance is to carry.
Yeah. And I agree with that, Mr. Townsend, and you know, we could say, all right, well, we want to build a nice house that's going to encroach in the setback. Here you've got plans that show the house, and we've gone through it in some detail for those encroachments that justify that 9.8-foot side yard setback.
In terms of the record, the only thing that was submitted on the, with the packet was the house placement plan. So the house plans that you showed us before have not been submitted.
I think they're part of the well, we had them on the board, but the basis for the variance is the footprint. I mean, the elevation, that's all well and good, but the encroachment is where that foundation, where that structure encroaches
I
into the...
understand that, but the extent you're saying that your clients, we want to know what we're getting. If you have plans that show what you're going to do, then we should see them.
We showed them to you, Mr. Capone.
You did. Now, you want them in the record, or?
I don't have any problem admitting them into the record. My point is that you all, and Mr. Townsend, you can talk about this all you like. You know, we don't grant setback variances on a pretty picture. We grant setback variances on a site placement plan, which is what you've got. But we'll submit this into the record. I'm not going to submit all of them, but I'll submit the two that we
It is the case that this variance could be granted and the property could be sold to somebody tomorrow who's got a completely different notion. And that's technically true. I think it's very unlikely, given what we've heard today, but that's technically true. I don't know that that's a big... we don't... It is not favored that the board would engage in something that's like akin to contract zoning, where you give us what we want and we'll give you the relief that you want. We're not here to design the house. That's not our role. The question here is whether you're going to grant an approval, whether you're going to grant a modified approval, or whether you're going to deny the application.
Could I ask Mr. Townsend a question? So is there an opportunity to say, just kind of making a decision on hold, and they can take their plans to the building department and get it? I mean, I've been around a long time in this town, and I know that people have sat before us and sworn under their oath that this is what they're going to build and this is what they're going to do with the property. And as soon as they get approval for something, they go off and do something else. So that's kind of, breeds a little cynicism.
So we did get a comment from staff about that we've got an application here and the relief is for, I think it's 9.8 feet along the entire boundary. If we engage in something that results in a challenge for the building official to enforce, then we may be we may be engaging in a process that we shouldn't be. So the application is for 9.8 feet. It seems that it's not going to be easy based on this drawing to grant a modified approval that doesn't put the building official at a loss as to whether a minor modification from this is permitted or not permitted based on the motion.
No, that was my question was, can we postpone making a decision and they can take plans to the building inspector and we have a better sense of, or no?
I suppose the applicant could ask us to do that, but I don't think we could impose that requirement on the applicant.
That's what
They're
I
entitled
asked.
to an answer to their application.
Okay, thank you.
All right, is there a motion?
I'll go back to my original motion that I believe that we should grant the 9.8 side setback.
Is there a second?
No, I'll second that motion.
Okay. So now we're going to vote.
Well,
Start with-
discussion?
Discuss it? Yes, we have to, you know what, I'm sorry. You need to give your rationale.
Yes, I would. I think that this type of lot is exactly the reason that we have this board to review, because all of the rules that we have set up cannot apply to every lot in town. It's just not possible. And I believe this is the mechanism that when they even change the setbacks, realize that there would be some difficulties and with some lots, and that this was the mechanism to try and seek some sort of resolution if that impacted. I don't believe that this has any negative impact on the home behind, as sort of at least questioned by the letter writer. And I do think that it is a challenge to try and go by all of the regulations that we have set up because of this unusual shape for the lot. And the one other thing is, because there is a setback in this lot from the road, I also think that it does not impact the safety. I think that visually, even, if there was a fence along the whole area there, people are going to be able to not only see, but they're also going to be able to walk and not have to be in the street and be on city land. So it does not present a safety issue either.
Yeah, sure, Jerry. I feel that the failure to remove the restrictions on the applicants probably would create exceptional practical difficulties for them. And Mr. Robinson stated in his letter, which I thought was interesting, the result of this calculation is that the side yard setback among the westerly boundary is itself wider than the rear lot. This is an unusual situation with an unusual lot. I also believe in changing the setbacks on the applicant's property will not seriously affect the surrounding properties. And what they're asking for is actually on State Road. And you do, as Randy said, you do have that 9.8 feet of city property as well. So in a sense, with that, plus there you get to the 29.8. And I think that you're, trying to alleviate the off-site, off-street parking by configuring the house the way they did that. So, so I vote in favor of the motion.
I vote against the motion. I think we're opening up. I'm sorry, Ann. I vote against the motion, and I do it reluctantly, but I think that it's too broad. And as I learned today, that there's more things that can happen if it's this broad. I'm really, really sorry that the applicants did not have maybe Mr. Robertson as their attorney at the beginning, or they didn't have a realtor that gave them the information about what they could build. But I think that I think it's inappropriate, and I don't think you should count the city property along the side of your property as belonging to you and giving open space when the city could do anything they want with it. So that's why I'm voting against it.
Okay. So it's down to me. I'm going to vote in favor of the motion. It's my vote is in favor of the motion. The reason for my decision is that the setback that we're discussing in this case is on the west side of the property. It doesn't face any residential property whatsoever, and in fact, barely faces on any city of Rehoboth property. This is a very odd-shaped lot. I believe that the variance process was created to accommodate lots like this, where there's an odd shape. I also am informed by the fact that the Planning Commission in 2008 partitioned this property, knowing that it was going to result in a property that was going to be developed, and it was going to be a property with that was going to have problems because of its odd size. And I further note that at the time that the Planning Commission granted the partition, they were partitioning it with the understanding that there was a 16 feet total setback requirement and a 10 and minimum of 6. So I think when this property was subdivided, everybody was thinking it's going to be a problem, but we have 16 feet to deal with the setbacks. Unfortunately, the law changed, but that's why we have variances. And for those reasons, I don't think that this will have a negative impact on any of the neighboring properties. I think the design that you're envisioning is one that takes into account the unusual shape of the lot. Therefore, I'm voting in favor of the variance.
Thank you very much.
We're not done yet.
Where are we on the agenda?
One more item on the agenda. You folks are done. You don't need to stay if you want to. Okay? You're off the. So the last issue on the agenda is to set the time for the meetings. And, slow down?
No. Thank you.
Set the time for the meetings. I prefer afternoon meetings. They got to be on Monday, the fourth Monday of every month. And, but in terms of what time in the afternoon, I'm kind of flexible. Does anybody have a time that they need to have?
I can't have it before 2:30 because the traffic in us getting, I'm in Dover at another meeting on the fourth Monday of the month. Both meetings changed. This was originally a night meeting and, you know, everything changed with COVID. And it now takes me sometimes 30 minutes to get from 5 Points to the city, sometimes longer.
Well, then.
Well, sometimes longer. So I have to be in Dover for a meeting that starts at 10:30, and then I have to turn around and come. I've been doing it by Zoom until now, but I have to go back to it in person. So I was hoping we could do it, start at 2:30, and still get Ann out of here in time, even 3 o'clock, but 2:30 would cut it. I think I could make it back here by 2:30.
I don't have a problem with 2:30. I would like to start the meetings in time to try to get us out of here before 5 o'clock. But I'd like to get it done before dinner time for the most part. Mr. Mandel, is that a problem with you guys?
Not a problem at all. I know the Parks and Shade meets at 10:30 on the 4th Monday, 10, so that they have an early meeting, but 2:30 would be fine.
How do you guys feel about it?
Jerry, I'm fine.
2:30. So can I have a motion to amend the rules to set a 2:30 start time?
Sure, I'll make the motion to amend the rules. to
Second?
change-
I'll second it.
All those in favor say aye.
Thank you all very
All right,
much.
so our meeting time is 2:30. Motion to adjourn?
To adjourn.
Second, all in favor? Aye, we're adjourned.
All right, thank you. I think we have to sign some, Ann. Oh. We have to sign some.